Now, it's important to understand that a partial plan termination is determined based on a facts and circumstances test, and the test is not a simple one. The 20% rule that we discussed in the prior module, it's a guideline, not a rule. Partial plan termination. Let's look at some other ingredients in this test. First of all, it does not have to occur, this reduction, whether it be a reduction in employees, eligible, or contributions and benefits. It doesn't have to be a single event, so events or actions can be aggregated over a period of time, which the IRS will determine is appropriate or not, and that the 20% then can occur with multiple actions being taken. So an example of this is if you have a layoff and you lay off 10% of your people in September of 2025, and then you lay off another 10% in May of 2026. It's very likely, though, that these two reductions in people will be aggregated and can then lead to a partial plan termination. Following in that line of logic, a reduction of less than 20% may also trigger a partial plan termination. As I said, the formula is extensive and it's not a simple one. So you're best to seek the counsel of an ERISA attorney if you think that you might be breaching this level of plan termination. And you can apply to the IRS for a determination letter, and they'll tell you if this partial plan termination has been triggered or not. The main difference between the partial and the full termination, other than the obvious, is that the vesting has to be applied at 100%, but only for those people who are affected by the partial plan termination. In other words, if you do terminate 20%, or let's say 25% of your population, the IRS confirms it's a partial plan termination, and those 25% have to be treated as fully vested and having full vesting rights. This is a major difference between a partial and a full plan termination. So let's talk about plan freeze, which is another option upon a corporate transaction, termination, merger, etc. The plan is considered frozen when no participant is considered benefiting for any particular year, benefiting for a defined contribution. Plan means an allocation of either a contribution, any kind of contribution, employee or employer, or a forfeiture is made to an account. A plan freeze is typically used if an acquisition is already closed without prior termination of the plan and due diligence of the acquired seller's plan, or when a plan inadvertently is acquired and the buyer wants new employees to participate in the buyer's plan, the existing plan, or the successor plan. So that's typically when you get involved with plan freezing. Also, though, a plan freeze is the optimal course of action if the buyer intends to restart or unfreeze that same plan at a later date, or the buyer desires to merge the plan into the buyer's plan, the successor plan, but only after it conducts post-close due diligence. There are a number of considerations that should be looked at when considering freezing a plan. The first is plan freezing does require a formal corporate action. Once again, a board or committee resolution and a plan amendment is required by the plan sponsor. The plan must continue, by the way, to satisfy all ERISA and IRC requirements in terms of plan management while it's frozen, which means 5,500 plan documents and amendments must be maintained in current, and all required distributions must be delivered to participants in continuation of monitoring not only the investments, but of course, the expenses as well. And the expenses must continue to be reasonable during the period at plan if the plan is frozen.